Disclaimer: the content provided on this channel is for general informational and educational purposes only. It is not legal advice. I am not a licensed attorney. Viewing this content, commenting, or engaging in any communication with the creator of this channel does not create an attorney-client relationship, nor is any communication considered privileged or confidential. The law is complex and varies significantly by jurisdiction. The information presented may not be applicable in your specific state or country. For advice on your individual legal situation or issue, you must consult with a licensed attorney in your jurisdiction. Do not act or refrain from acting based on the content of this channel.
Imagine you found it. The perfect house. The one with the big backyard for the dog, the sun-drenched kitchen, the school district you've been dreaming of. You've gone through the emotional roller coaster of making an offer, the nail-biting negotiation, and finally, it's accepted. You've signed the initial papers, you're scheduling movers, you're picking out paint colors. You are on top of the world. Then, 2 weeks before you're supposed to get the keys, you get a call from your agent. There's a problem. A cloud on the title. A what? Suddenly, your dream home is tangled in a legal nightmare you didn't even know could exist. A contractor from 5 years ago put a lien on the house for an unpaid bill. A long-lost heir of a previous owner is making a claim. The property line isn't where everyone thought it was. This is the exact moment a real estate lawyer transforms from just another name on a closing cost checklist to the single most important person on your team. Over the next few minutes, we're going to pull back the curtain on what a real estate lawyer actually does. And let me tell you, it is so much more than just shuffling papers and stamping documents. We are going to break down the critical deal-saving, money-protecting roles they play that no one else in the transaction can. By the end of this video, you will not only understand their job, you will know precisely when and why you might absolutely need one on your side. A decision that could save you tens of thousands of dollars and a mountain of stress. So, let's start with the single biggest, most misunderstood, and frankly most vital job a real estate lawyer performs, the title examination. Now, when you hear the word title, you might think of that fancy piece of paper you get for your car. But in real estate, the title isn't really a physical document. It's a concept. It is the legal theory of ownership. It's your bundle of rights to a property, the right to possess it, to use it, to sell it, and to keep others off of it. A clean title means you, and only you, hold that complete bundle of rights, free and clear of anyone else's claims. A dirty title, or one with a cloud on it, means someone else might have a legitimate claim to a piece of your ownership bundle, whether you know it or not. The lawyer's job is to act as a property detective. They conduct what's called a title search, which is a deep, forensic investigation into the history of your property. They go back in time, sometimes 50, 60, even 100 years or more, meticulously examining every public record connected to that piece of land. They're digging through deeds, mortgages, wills, divorce decrees, court judgments, and tax records, all held at the county recorder's office. They are building a family tree for your house, tracing the ownership from person to person, transaction to transaction. This is called the chain of title. And they are looking for any weak links in that chain. They are hunting for ghosts. What kind of ghosts are we talking about? Let's get specific. First and most common are liens. A lien is a legal claim against a property for an unpaid debt. The most common is the seller's mortgage, which obviously has to be paid off at closing. But the lawyer is looking for the hidden ones. For example, maybe the previous owner had a new roof put on 3 years ago and never paid the roofer the final $5,000. That roofer can file a mechanic's lien against the property. If it's not discovered and paid, that debt could legally become your problem. The roofer could, in a worst-case scenario, force the sale of your new home to get their money. Your lawyer is also looking for tax liens from unpaid property taxes or income taxes, and judgment liens, where the seller lost a lawsuit and the winner put a lien on their assets, including the house. Without a lawyer finding these, you could be inheriting a massive debt along with your new front door. Next, they're hunting for easements. An easement is the legal right for someone else to use a portion of your property for a specific purpose, even though you own it. Some are obvious and necessary, like a utility easement that allows the power company to access a pole in your backyard. But others can be shocking. Your lawyer might discover a recorded easement that gives your neighbor the right to use your driveway to get to their garage, or a conservation easement that prevents you from ever building that pool you were planning, or a prescriptive easement, where for the last 20 years, people in the neighborhood have been cutting across a corner of the property to get to a park, and now they have a legal right to continue doing so. These are things that won't show up on a standard home tour, but they can fundamentally change how you can use and enjoy your own land. Then there's the truly bizarre stuff that can break a chain of title. The lawyer is verifying that every single transfer of ownership was done correctly. A simple clerical error from 1972, where a clerk misspelled a name on a deed, could create a cloud. A forged signature on a sale from 1985 could mean the entire transaction was fraudulent, and the rightful owner's heirs could still have a claim. They might discover that a past owner passed away, and the property was sold by only one of their 3 children, meaning the other 2 still have a legal ownership stake in your new living room. These sound like movie plots, but they happen. The lawyer's job is to find these historical landmines before you step on them. They also scrutinize surveys and legal descriptions to look for encroachments. This is when a structure on a neighboring property like a garage, a fence, or a deck is actually built partially on your property. If that fence has been there for 10 years and no one said anything, your neighbor might have a legal claim to that strip of land through a concept called adverse possession. Discovering that your neighbor's shed is sitting 3 feet inside your property line is something you want to know before you buy, not after. So, after this exhaustive investigation, the lawyer prepares a title report, or an abstract of title, which is a summary of everything they found. If it's clean, fantastic. But if it's not, their job isn't just to find the problems, it's to help fix them. They'll work with the seller's attorney to pay off old liens, get legal releases signed, or file court actions to quiet the title, which is essentially a lawsuit to clear up any ambiguities and get a judge's definitive ruling on who owns the property. This entire process culminates in the single most important piece of protection you can get as a homebuyer: title insurance. Based on their clean and certified examination of the title, the lawyer can get a title insurance company to issue a policy. Now this is crucial. There are 2 types. The lender's policy, which is almost always required, protects the bank's investment in your property, but it does not protect you. The one you need is the owner's policy. You pay for it once, a single premium at closing, and it protects you for as long as you or your heirs own the property. It is your financial force field. If some goes from the property's past, that long-lost heir, that forged signature from 1985, comes back to make a claim against your home, the title insurance company is legally and financially bound to defend you. They will pay for all the court costs, all the legal fees, and if the unthinkable happens and you lose, they will compensate you for the financial loss of your property. Buying a home without an owner's title insurance policy is one of the riskiest financial decisions a person can make. And it's the work of your real estate lawyer that makes that protection possible. They are the gatekeeper to your peace of mind. So what exactly are they guarding you from? They're guarding you from the past. Every piece of property in America has a history, a story stretching back decades, sometimes centuries. That story is documented in a series of public records, deeds, and legal filings. This continuous line of ownership is called the chain of title. Think of it like a family tree for your house. It shows who owned it, who they sold it to, who that person sold it to, and so on, all the way back to the original land grant. In a perfect world, this chain is a clean, unbroken series of links. But we don't live in a perfect world. And a single broken, rusted, or fraudulent link in that chain can completely invalidate your ownership of the property you just paid hundreds of thousands of dollars for. This is where your lawyer puts on their detective hat. Their first and most critical job is to conduct what's called a title search. They go back in time, meticulously examining every single link in that chain. They aren't just looking for names and dates. They are hunting for ghosts. Financial ghosts, legal ghosts, and familial ghosts that can haunt a property and turn your American dream into a waking nightmare. Let's talk about the most common ghost: the lien. A lien is essentially a legal claim against a property for an unpaid debt. Let me paint a picture for you. The previous owner of your dream house, let's call him Bob, decided to get a new roof 5 years ago. He hired a contractor, the work was done, but Bob never paid the final $10,000 invoice. The contractor, rightfully angry, filed a mechanic's lien against the property. This is a legal document recorded in the public records that says, "This property cannot be sold with a clean title until my $10,000 debt is paid." Now, Bob conveniently forgets to mention this when he sells you the house. Without a lawyer conducting a thorough title search, you would buy that house, and you would also buy that $10,000 debt. That contractor can now come after you for the money. In some cases, they can even force the sale of your new home to get paid. And it's not just contractors. There are tax liens from the IRS or the state for unpaid income taxes. There are judgment liens from lawsuits Bob lost. Maybe he lost a civil suit after a car accident, and the victim put a $50,000 lien on his house. Suddenly, that beautiful home you bought is just a liability, a hostage to someone else's bad decisions. Your lawyer is the one who scours the records to find these financial landmines before you step on them. Then there are easements and encroachments, two legal terms that sound boring, but can completely upend your life. An easement is the legal right for someone else to use a portion of your property for a specific purpose, even though you own it. The most common are utility easements. The power company might have the right to access a 10-foot strip along the back of your yard to service power lines. That's usually not a big deal. But what if there's a more serious, unrecorded easement? Imagine you buy a beautiful, secluded property with a long private driveway. You love the privacy. A month after you move in, you discover your neighbor has a legal easement to use your driveway to get to their landlocked property behind yours. Suddenly, you have cars driving past your living room window at all hours. Your privacy is gone, and there's nothing you can do about it. Your lawyer's job is to find these documented rights before you buy, so you know exactly what you're getting. An encroachment is the flip side. It's when a neighbor's physical structure illegally intrudes onto your land. That shed your new neighbor built? Your lawyer's title search, often combined with the property survey they recommend, might reveal it's actually 3 feet onto your property. That beautiful oak tree whose shade you fell in love with? The survey might show it technically belongs to the guy next door, who can legally cut it down tomorrow. These seem like small issues, but they can lead to incredibly bitter, expensive, and emotionally draining disputes with neighbors. Your lawyer identifies these problems up front, turning a potential war into a simple negotiation point before you even sign the papers. But this is where it gets truly terrifying. We're not just talking about debts and boundary lines anymore. We're talking about fraud, forgery, and identity. What if the person who sold the house to the person you're buying from never actually owned it? It happens more than you think. A scam artist could forge a seller's signature on a deed, file it with the county, and sell a property they have no right to. They take the money and vanish. The real owner might not even know it happened until months later. Now the person you're buying from, who bought it from the forger, has what's called a void title. It's worthless, and if they sell it to you, that worthless title passes to you. You could pay $500,000, move your family in, and then have the real owner show up with the police proving the forgery. In the eyes of the law, you are a trespasser in a house you just paid for. You lose the house and your money is gone. Your real estate lawyer investigates the legitimacy of every transfer, cross-referencing signatures, checking notary records, and looking for red flags that suggest a fraudulent transaction somewhere in the property's history. They are your defense against the con artists and criminals who prey on the complexity of real estate transactions. And finally, there are the ghosts within the family. These are often the saddest and most complicated cases. Let's say a woman, Mary, owned her home outright. She passes away without a will. According to state law, her property passes to her 2 children, John and Jane. John, wanting to sell quickly, tells his lawyer and the title company that he is the only heir. He might even forge documents to prove it. He sells you the house and disappears with the money. A year later, his sister Jane, who was living out of the country and had no idea her mother had passed, comes back. She discovers what John did, and she has a perfectly legal 50% claim to your house. She can sue you, force a partition sale, and you are now stuck in a legal battle that will cost you tens of thousands of dollars, all because of a family dispute you had nothing to do with. A skilled real estate lawyer knows how to investigate heirship. They look at probate court records, obituaries, and other documents to verify that all potential heirs were properly notified, and that the person selling the property has the full legal authority to do so. They protect you from skeletons in someone else's family closet. Each of these problems, liens, easements, fraud, unknown heirs, is known as a cloud on the title. It's an issue that makes the ownership uncertain and questionable. The lawyer's title search is a mission to find and identify every single one of these clouds. So what happens when the detective finds a problem? When your lawyer uncovers a $20,000 lien from a forgotten hospital bill, or a forged signature from 2 decades ago? Is the deal dead? Is your dream home lost forever? Not necessarily, because this is the moment the detective takes off their hat and becomes the problem solver. This is where the magic really happens. It's the difference between a deal falling apart in a storm of panic and finger-pointing, and a deal closing smoothly, with you barely even knowing a hurricane was ever on the horizon. The lawyer's job is to take these seemingly catastrophic problems, these ghosts from the property's past, and systematically make them disappear. This process is called curing title defects, and it's part legal strategy, part high-stakes negotiation, and part creative problem-solving. Let's start with that lien. A $20,000 claim slapped on the property from a contractor the seller hired 5 years ago to redo the roof. The seller swears they paid it. The contractor's company is now out of business, but the lien is still there. A big red stop sign on the public record. You can't get a mortgage, you can't get title insurance, you can't close. So what does the lawyer do? First, they don't just take the lien at face value. They investigate it. Was it filed correctly? In many states, a contractor's lien or a mechanic's lien has a very strict, very short deadline to be legally enforced. If the contractor didn't file a lawsuit to foreclose on that lien within, say, 1 year, the lien might be completely void. It's like a ghost still haunting the house, but it has no power. Your lawyer would then use the proper legal procedures to have that expired, unenforceable lien formally removed from the record, and poof, the problem vanishes. But let's say the lien is valid. The seller simply forgot to pay the last installment. Now it's a negotiation. The seller doesn't have $20,000 sitting around. You, the buyer, certainly aren't going to pay it. A novice might just throw their hands up. But your lawyer sees an opportunity. They get on the phone. They track down whoever now owns that debt. They don't just ask, how much to make this go away? They build a case. They say, look, this deal is going to die without a compromise. The seller will walk away, the house will go back on the market, and you'll be stuck trying to collect from a person who has no assets other than a house they can't sell. Or you can work with us. We are closing in 2 weeks. We can get you a certified check from the closing table. Let's talk about a real number. Suddenly, that $20,000 lien, which was mostly interest and penalties, becomes a $15,000 problem. Then a $12,000 problem. The lawyer might negotiate a final settlement of $10,000, which the seller agrees to have deducted directly from their sale proceeds at closing. The lawyer drafts a settlement agreement, arranges for the funds to be set aside by the closing agent, and ensures a legally binding release of lien is signed and ready to be recorded the very second the deal is done. You, the buyer, experience none of this drama. You just get a call from your lawyer saying, that title issue we mentioned? It's been handled. Now what about something physical? That boundary line issue. The survey comes back and shows the neighbor's beautiful new fence is actually 3 feet onto the property you're about to buy. This is a classic encroachment. It's a cloud on your title because someone else is physically occupying a piece of your land. Again, is the deal dead? The confrontational approach is to march over there and demand the neighbor tear down their fence. That's a great way to start a decade-long feud with the people you'll be living next to. The lawyer's approach is different. They look for the path of least resistance that still completely protects you. Maybe they review the neighbor's deed and survey and discover a mistake was made, and the fence is in the right place after all. Problem solved. Or if the fence is indeed encroaching, the lawyer might suggest a boundary line agreement. This is a formal recorded document where you and the neighbor both legally agree on the exact location of the property line. It resolves all ambiguity for the future. Or even simpler, they might draft an easement. They could have the neighbor pay a nominal fee for a fence easement, which gives them the legal right to keep the fence where it is, but makes it crystal clear that the land under it still belongs to you. The title insurance company is happy because the issue is legally documented and resolved. You're happy because you didn't have to start a war. The deal moves forward. But what if the problem is more severe? What if the seller's entire garage was built partially on the neighbor's land? Or what if the title search uncovers a messy, unresolved inheritance from 50 years ago, with a dozen potential heirs who might have a claim? For these tangled, complex messes, the lawyer has a powerful tool called a quiet title action. This is the legal equivalent of a factory reset for a property's title. The lawyer files a lawsuit not against one person but against the entire world. They legally notify anyone and everyone who could possibly have a claim to the property. They present all the evidence to a judge, and the judge issues a final, binding court order that acts like a lightning bolt from the heavens. It declares with absolute authority who the true owner is and extinguishes, forever, all of those other old, questionable, or fraudulent claims. It wipes the slate clean, rendering the title pristine and marketable. This brings us to the scariest scenario: fraud. That forged signature from 2 decades ago. Someone sold the property who didn't have the right to. This sounds like an absolute deal killer. And sometimes it is. But not always. This is where your lawyer's relationship with the title insurance company becomes your single greatest asset. The lawyer isn't just your representative. They are a trusted gatekeeper for the title insurer. They can present the facts and make a compelling argument about risk. They might say, yes, this signature from 1998 looks questionable. However, the property has been sold 3 times since then. The supposed real owner has been silent for 25 years. Property taxes have been paid by the new owners that entire time. The risk of this person suddenly appearing and making a valid claim is infinitesimally small. The lawyer, in essence, vouches for the transaction. Based on their lawyer's analysis and reputation, the title insurance company might agree to insure over the defect. This is a critical concept. They are saying, we acknowledge this old, weird issue exists, but we are willing to take the financial risk. We will issue a policy that protects the new buyer and the lender, and if that goes from 1998 ever does show up, we, the multi-billion-dollar insurance company, will be the ones to fight them and pay the price, not you. Without the lawyer advocating for you, the title company would have simply said, no, we won't insure this. Deal's off. But with the lawyer as the problem solver and negotiator, the uninsurable becomes insurable. The deal killer becomes a footnote. This ability to analyze, negotiate, and resolve these hidden landmines is a core function. But it's all reactive. It's about fixing problems that have already happened. The true genius of a great real estate lawyer, however, lies in preventing problems from ever happening in the first place. And that all starts with the most important document in the entire transaction. It's the blueprint, the battle plan, and the rulebook all rolled into one. It's not the deed, and it's not the mortgage. It's the contract you sign right at the beginning, the purchase and sale agreement. And the standard fill-in-the-blank version that most people use is a minefield of vague language and hidden traps, just waiting to blow up your deal. Let's talk about that purchase and sale agreement. Most real estate agents will pull out a standard state-approved form. It's got a lot of blanks, you fill them in, everyone signs, and you pop the champagne, right? Wrong. That standard form is written to be neutral, but in practice, it often favors the seller. It's designed to get the deal done, not necessarily to protect you. Your lawyer's first and arguably most critical job is to take that standard form and turn it into your personal suit of armor. They do this with something called a rider or an addendum. This is a separate document that modifies, adds to, and clarifies the standard contract, tailoring it to your specific situation. Think of it like this. The standard contract is an off-the-rack suit. It might fit, sort of, but the sleeves are too long, it's tight in the shoulders, and it's not really your style. The lawyer is the master tailor who custom fits that suit so it's perfect for you, protecting you in all the right places. The single most important area they work on is what we call contingencies. These are the escape hatches in your contract. They are the clauses that say, I agree to buy this house if, and then list a bunch of conditions. If those conditions aren't met, you can walk away from the deal and, most importantly, get your earnest money deposit back. Without strong, clear contingencies, that deposit money is at serious risk. Let's start with the big one, the inspection contingency. The standard form might say something like the contract is contingent upon a satisfactory home inspection. What on earth does satisfactory mean? Satisfactory to whom? Does a leaky faucet count? What about a 20-year-old roof that has a few years left but will need replacing soon? The seller will argue that's all minor stuff, perfectly satisfactory for a house of its age. You, on the other hand, are looking at thousands of dollars in future repairs you didn't budget for. This ambiguity is where deals go to die, and where buyers lose their deposits. Your lawyer rips that vague language out. They replace it with surgical precision. The rider they draft will specify exactly what you can object to. For example, it might state that you can terminate the contract or renegotiate if the inspection reveals any single defect that will cost more than, say, $1,000 to repair, or a collection of smaller defects that add up to over $2,000. It will clearly define what happens next. It gives you specific options. You can demand the seller fix the issues, you can ask for a credit at closing to fix them yourself, you can renegotiate the purchase price, or if the problems are too big, you can activate the escape hatch, cancel the contract, and get your full deposit back, no questions asked. This single change transforms the inspection from a source of potential conflict into a clear, structured negotiation. Next up is the financing contingency. This is your protection if your mortgage falls through. The standard contract usually says you have to make a good faith effort to get a loan. But what if you get approved but the terms are terrible? What if the only loan you can get is an adjustable rate mortgage with a sky-high interest rate that will wreck your budget in 3 years? Technically, you got a loan, According to the standard contract, you might be forced to either accept that predatory loan or forfeit your deposit. Your lawyer prevents this nightmare scenario. They draft a financing contingency that is incredibly specific. It will state that your obligation to buy the house is contingent on you securing a loan for a specific amount, at an interest rate not to exceed a certain percentage, for a term of a specific number of years, say a 30-year fixed. If you can only get a loan that's worse than those terms, you can walk away deposit in hand. It also protects you from last-minute lender issues. Sometimes a bank will issue a commitment letter, but include a bunch of tricky last-minute conditions. Your lawyer's rider ensures that you need to receive a firm, unconditional loan commitment by a certain date. If the bank starts playing games, your exit is secure. Then there's the appraisal contingency. The bank is only going to lend you money based on what the house is worth, not what you agreed to pay for it. So what happens if you agree to pay $500,000, but the independent appraiser hired by the bank says the house is only worth $470,000? Now you have a $30,000 gap. The bank will only give you a loan based on the $470,000 value. Where does that extra $30,000 come from? Without a proper contingency, you're in a terrible position. You might be legally obligated to come up with that $30,000 in cash, or else you're in breach of contract and could lose your deposit. A lawyer's rider creates a clear three-pronged plan of action for this exact situation. Option 1. The buyer and seller agree to renegotiate the price down to the appraised value. Option 2. You, the buyer, can choose to make up the difference in cash if you still want the house. Option 3. If neither of those options works, you can cancel the contract and get your deposit back. It removes the panic and the ambiguity, giving you a clear pre-negotiated roadmap for a very common problem. Beyond the big contingencies, a lawyer sweats the small stuff that can become big stuff. Take the as-is clause. Sellers love to sell a house as is because it sounds like they have no responsibility. But as-is doesn't give a seller the right to lie or conceal known major problems, like a cracked foundation they painted over. Your lawyer will clarify the as-is language to make sure it doesn't waive your right to a thorough inspection and doesn't let the seller off the hook for failing to disclose significant latent defects that they knew about. They also act as the unforgiving project manager of your deadlines. A real estate contract is a web of critical dates. The deadline to get your inspection done, the deadline to secure your loan commitment, the deadline for the title search. If you miss one of these deadlines, even by a day, the standard contract often states that you have waived your contingency. Miss your inspection deadline? You just bought the house as is, problems and all. Miss your financing deadline? The seller might be able to cancel the contract and keep your deposit. Your lawyer calendars every single one of these dates, sends you and the other parties reminders, and if necessary, proactively negotiates extensions before a deadline is missed. They are the guardian of the timeline that protects your money. And finally, they handle the little things that can turn into closing day shouting matches. You saw the house and it had a beautiful high-end Viking stove, a brand new smart washer and dryer, and gorgeous custom chandeliers in the dining room. You assume they come with the house. The seller assumes they're taking them. The standard contract might just say all fixtures included, but the line between a fixture and personal property can be surprisingly blurry. Is a mounted flat-screen TV a fixture? What about the Ring doorbell? Your lawyer doesn't leave this to chance. They create a specific list of every single item you expect to be included in the sale, from the kitchen appliances down to the drapes and window blinds, and they make that list part of the legally binding contract. So on your final walkthrough, there are no nasty surprises. What you saw is what you get. By the time your lawyer is done, that generic 2-page agreement has blossomed into a 10 or 15-page ironclad contract. It's no longer a simple form. It's a strategic document, custom-built to anticipate problems, manage risk, and give you power in the negotiation. This document, meticulously crafted before you're even locked into the deal, is the foundation upon which the entire, successful transaction is built. But a solid contract is only the beginning. Once everyone has signed on the dotted line, a new, far more complicated process begins, one that happens almost entirely behind the scenes. It's the process of making sure the seller actually has the legal right to sell you the house in the first place. This is called a title search, and it's one of the most critical, yet invisible jobs your lawyer performs. Think of it like a forensic investigation into the property's past. Your lawyer becomes a detective, a historian, and a legal bloodhound all rolled into one, digging through decades, sometimes centuries of public records. They're looking for a perfect, unbroken chain of ownership, what we call the chain of title. Every link in that chain represents a transfer of ownership, from one person to another, from a parent to a child, from a developer to a family. Each link must be solid, legally sound, and properly documented. If even one link is weak, cracked, or missing, the entire chain can fall apart, and your claim to the property could be in jeopardy. Imagine a couple, let's call them the Jacksons. They found their dream home, a beautiful Victorian with a wraparound porch. They signed the contract, got their mortgage approved, and were already arguing about what color to paint the living room. Everything seemed perfect. Meanwhile, their real estate lawyer was in the county records office, a place that smells of old paper and forgotten stories, pulling massive leather-bound books off shelves. As he traces the chain of title back, he hits a snag. In 1952, the property was owned by two brothers, John and Robert. In 1968, John sold the property. The deed was signed, the money was paid, and the new owner took possession. The problem? Only John's signature is on that deed. Robert's is nowhere to be found. Where was Robert? Did he die? Did he agree to the sale and just forget to sign? Or was he cheated out of his inheritance by his own brother? The records are silent. This is what lawyers call a cloud on the title. It's a potential claim, a question mark, a ghost from the past that haunts the property's legal status. Without Robert's signature or proof that he legally transferred his half to John, there's a very real possibility that Robert, or more likely his heirs, still legally own 50% of the Jacksons' dream home. Now, think about what would happen if the Jacksons had bought that house without a lawyer doing this deep dive. They move in, they raise their kids, they pour their life savings into renovations. Then, 20 years later, a letter arrives. It's from a lawyer in another state representing the grandchildren of Robert, who they've just discovered. They have a valid legal claim to half of the Jacksons' house. Suddenly, the Jacksons are facing a nightmare. A costly legal battle. The possibility of having to buy their own home a second time from these newly discovered heirs, or even being forced by a court to sell the house and split the proceeds. Their entire life's investment could be wiped out by a missing signature from over half a century ago. This is where your lawyer truly earns their fee. They don't just find the cloud. Their job is to make it disappear. This process is called curing the defect. It's an active, often complex, legal procedure. First, they'd launch an investigation. They might hire genealogists to build Robert's family tree and track down his living descendants. They'll search for marriage certificates, death certificates, and old wills. Anything that could shed light on what happened to Robert's share of the property. Let's say they find Robert's grandchildren. The lawyer's next step is negotiation. They'll explain the situation and often offer a modest sum of money in exchange for them signing a quitclaim deed. This is a legal document where they officially relinquish any and all potential claims to the property, effectively fixing the broken link in the chain from 1968. Most of the time, heirs who never even knew the property existed are happy to sign for a few $1,000s. But what if they refuse? What if they see a payday and demand an outrageous sum? If negotiation fails, the lawyer's final weapon is a lawsuit called an action to quiet title. They literally sue the missing heir or their descendants, or even any and all unknown potential heirs. They present all the evidence to a judge, the decades of undisputed ownership by subsequent families, the property taxes paid, the lack of any claim from Robert for over 50 years. The judge can then issue a court order that acts like a legal sledgehammer, extinguishing the old phantom claim and declaring that the seller is, in fact, the one true and clear owner. The cloud is gone. The title is now clean and marketable. While the Jacksons were picking out kitchen countertops, their lawyer was a detective, a negotiator, and a litigator, solving a 50-year-old family mystery to protect their future. This is happening silently in the background of thousands of real estate transactions every single day. But what if the detective misses a clue? What if a document was forged so perfectly it's undetectable? What if a secret will was hidden in an attic and only discovered years after you've moved in? No lawyer, no matter how good, is infallible. The records themselves can be flawed. This is why the second part of this process is just as crucial: title insurance. After the lawyer has done their search and is satisfied that the title is clean, they will work with a title insurance company to issue a policy. Now, this is important because there are two kinds and you need to understand the difference. The first is the lender's policy. Your mortgage company will absolutely require this. Protects them. If some long-lost heir pops up and wins a claim, the lender's policy ensures the bank gets its loan money back. But it does absolutely nothing for you, the homeowner. You could lose the house and all the equity you've built, but hey, the bank is protected. The second type is the owner's policy. This is the one that protects you. In most states, it's technically optional, but you should consider it absolutely mandatory. An owner's title insurance policy is your shield. It's a one-time fee you pay at closing, not a monthly premium, and it protects you for as long as you or your heirs own the property. If that same long-lost heir shows up after you've closed, you don't have to panic. You just call your title insurance company. They are now legally and financially obligated to handle it. They pay for the lawyers. They pay for the court battles. And if the heir somehow wins, the insurance company pays you for the financial loss, up to the full purchase price of your home. Your lawyer's role is to ensure you get this policy, and to explain its importance. They review the policy itself, making sure there are no strange exceptions or loopholes that could leave you exposed. They are essentially double-checking the work of the title company and advocating for the most comprehensive protection for you. The title search is the investigation to find all the known threats. The owner's title insurance policy is the armor that protects you from all the unknown ones, the threats that no one could possibly find. It's the final step in ensuring that the home you're buying will be legally and truly yours, free from the ghosts of the past. So now the contract is signed, the inspections are done, the title is cleared and insured. The legal foundation of the deal is solid. The next stage is all about the money. And we're not just talking about the purchase price. We're talking about a complex web of credits, debits, taxes, and fees that all have to be calculated, collected, and distributed with perfect accuracy. And the master document that orchestrates this entire financial symphony is called the closing disclosure, or the CD. For deals without traditional financing, you might see a similar document called a HUD-1 settlement statement. Whatever its name, this document is the financial blueprint of your transaction. It is, without exaggeration, one of the most important and densely packed financial documents you will ever encounter. It's a multi-page grid of numbers that tells the complete story of the money, where every single dollar comes from, and where every single dollar goes. And your lawyer's job is to become the absolute master of this document. They don't just review it. In many cases, they are the ones who prepare it, building it from the ground up, line by line. Think of your lawyer as the financial quarterback of the closing. They're not just on the field, they're calling the plays. They have to get the final loan amount and a list of all lender fees from the buyer's bank. They have to request a payoff statement from the seller's mortgage company, accurate to the very day of closing. They have to contact the local tax assessor to get the exact property tax figures for the year. They have to get the homeowners association dues and any special assessments. They have to confirm the real estate agent commissions. They are the central hub, the single point of contact where all these disparate financial streams converge. And their mission is to assemble this puzzle into a single, flawless, legally binding document. Let's pull back the curtain on this document, because understanding it is the key to understanding the financial core of a real estate transaction. The closing disclosure is essentially a giant balance sheet, split right down the middle. On one side you have the seller's column and on the other the buyer's. Each side has its own set of debits and credits. A debit is a charged money you have to pay out. A credit is money you are receiving. The goal for both the buyer and the seller is to have all the debits and credits add up perfectly, resulting in either the final amount the buyer needs to bring to closing or the final amount the seller will walk away with. For the buyer, the biggest credit is obvious, the new loan they're getting from the bank. The biggest debit is also obvious, the purchase price of the home. But the magic and the potential for disaster lies in the dozens of other line items. This is where the lawyer's precision becomes invaluable. Let's talk about prorations. This is a concept that trips up so many people, but it's actually quite simple. It's the process of splitting costs that are paid on a schedule, like property taxes or HOA fees, so that the seller only pays for the days they own the property, and the buyer only pays for the days they will own it. Imagine the annual property tax bill is $12,000, or $1,000 a month, and you're closing on June 30th, exactly halfway through the year. The seller has lived in the house for the first 6 months. The buyer will live there for the last 6. Seems simple, right? The seller should be responsible for $6,000, and the buyer for $6,000. But property taxes are rarely paid on the day you owe them. Maybe the seller already paid the entire $12,000 bill back in January. In that case, on the closing disclosure, the buyer would owe the seller a credit of $6,000, reimbursing them for the half of the year the buyer will own the home. But what if the tax bill isn't due until December? In that case, the seller hasn't paid anything yet. So at closing, the seller must give the buyer a $6,000 credit. The seller is essentially handing the buyer the money to cover their portion of the bill, which the buyer will then pay in full at the end of the year. Now, imagine your lawyer gets this calculation wrong. A simple mistake, misreading the tax period, using last year's tax rate, or miscalculating the number of days, could create a swing of thousands of dollars. I've seen cases where a lazy title clerk forgot to collect the seller's portion of the taxes. The buyer closed, got their tax bill in December, and suddenly realized they were on the hook for the entire year, including the 6 months the seller lived there. The seller was long gone, and the buyer was stuck with a massive, unexpected bill right before the holidays. A diligent real estate lawyer prevents this. They verify the tax figures directly with the municipality, they calculate the per diem rate down to the penny, and they ensure that proration is a perfect reflection of each party's responsibility. This same principle applies to everything: HOA dues, condominium fees, even fuel oil in a tank. If the seller leaves behind a half-full tank of heating oil, the buyer is expected to pay for that oil. The lawyer will get a reading from the oil company on the day of closing and add a line item to the CD, ensuring the seller is compensated for the fuel they paid for but didn't use. These are the details that separate a smooth closing from a financial nightmare. Beyond prorations, the lawyer scrutinizes every single fee. The closing disclosure is broken down into sections: loan costs, other costs, and so on. Under loan costs, you'll see the lender's origination fee, the appraisal fee, the credit report fee. Your lawyer is checking these against the loan estimate you received when you first applied for the mortgage. There are strict federal laws about how much these fees can change between the estimate and the final closing. Your lawyer is your watchdog, ensuring the lender isn't slipping in last-minute junk fees or padding their numbers. Then you have the title and settlement charges. This is where the lawyer's own fees, the title insurance premiums we discussed earlier, and government recording fees are listed. A good lawyer will walk you through each of these, explaining what they are and why they are necessary. They'll confirm the recording fees with the county clerk to make sure you're not being overcharged. These might seem like small amounts, $100 here, $50 there, but they add up. More importantly, it's about the principle of accuracy. One of the most confusing sections for buyers is the prepaids and initial escrow payment at closing. This is where you pay for things up front. You'll likely pay for an entire year of homeowner's insurance premium in one lump sum. You'll also pay what's called prepaid interest. If you close on the 25th of the month, your first mortgage payment won't be due until the 1st of the next month. But the bank needs to collect the interest for those few days at the end of the current month. That's prepaid interest. Then there's the escrow account. Most lenders require you to have an escrow account, which is like a forced savings account managed by the bank to pay your future property taxes and homeowner's insurance. At closing, the lender needs to collect a cushion for this account, usually a few months' worth of tax and insurance payments. This is to ensure there's always enough money in the account to pay those bills when they come due. Your lawyer's job is to verify the lender's math. Are they collecting the right amount for escrow? Are they using the correct annual tax and insurance figures? An error here could mean your initial cash-to-close number is artificially inflated by hundreds or even thousands of dollars. After every number from every party has been collected, verified, and entered, the final, almost magical process of balancing occurs. The lawyer or their paralegal will stare at the bottom line of the closing disclosure. Total debits must equal total credits. To the penny. If it's off by even a single cent, the file doesn't balance and the closing can't happen. They will hunt through every line item, rerunning calculations, reconfirming figures, until the entire equation is perfect. This obsessive attention to detail is your ultimate protection. It ensures that the final cash-to-close figure for the buyer is precisely what it should be, and the net proceeds for the seller are exactly what they are owed. This isn't just about paperwork. It's about the sacred trust of handling hundreds of thousands, sometimes millions, of dollars of other people's money. The closing disclosure is the testament to that trust, and the lawyer is its architect and guardian. But guarding the money is only half the battle. The other half, guarding the property itself. Not the physical structure of wood and nails, but its legal soul. This is where the real estate lawyer transforms from an accountant into a historian, a detective, and a protector of legacies. They embark on one of the most critical and least understood journeys in the entire home buying process: the title search. Imagine you're buying a priceless work of art. You wouldn't just hand over the money based on a photo. You'd hire an expert to verify its provenance, to trace its history of ownership all the way back to the artist, ensuring no forgeries, no thefts, no hidden claims along the way. Your house, your future home, is infinitely more valuable than a painting. It's where you will build your life. The title search is its provenance check. It's the lawyer's deep dive into the public records, a meticulous excavation of the property's past, searching for ghosts. What kind of ghosts? Liens from unpaid contractors who renovated the kitchen a decade ago. Judgments against a previous owner for an old credit card debt that attached to the property like a barnacle. Easements granted to a utility company 50 years ago that give them the right to dig up your future backyard. A bitter divorce from the 1980s where one spouse never properly signed away their rights. Or the most terrifying ghost of all. A break in the chain of title, a moment in history where the deed was improperly transferred, forged, or never recorded, creating a fatal flaw in the very concept of ownership. The lawyer sifts through decades of digital and paper dust, deeds, mortgages, satisfactions, tax records, probate filings, and court dockets. They are looking for any cloud on the title. A cloud is any issue that could cast a shadow over your absolute, undisputed ownership. Finding one of these clouds is like a doctor finding a spot on an X-ray. It doesn't mean the patient is doomed, but it means a skilled professional needs to step in and fix it before it becomes catastrophic. Let's make this real. Meet the Jacksons. They've found their forever home. A beautiful colonial with a sprawling backyard. Perfect for their kids and their golden retriever. They're in love. They've signed the contract, secured their mortgage, and are dreaming of paint colors. Their lawyer, let's call her Sarah, begins the title search. Everything looks clean for the first 40 years. Deed from Smith to Jones, perfect. Jones to Brown, perfect. Then in 1998, Sarah hits a snag. The Browns sold the house to the current owner, Mr. Gable. But the deed was only signed by Mr. Brown. Where was Mrs. Brown? Sarah digs deeper. She pulls the divorce decree from 1999. It clearly states that Mr. Brown was awarded the house. But the decree also says Mrs. Brown was supposed to sign a quitclaim deed to officially relinquish her interest, and there is no record of that deed ever being filed. For over 2 decades, this legal loose end has been sitting there, a ticking time bomb. Legally, Mrs. Brown might still have a claim to the property. If the Jacksons were to buy this house, they would also be buying this massive, expensive legal problem. They could be buying a lawsuit. This is where the lawyer earns their fee 10 times over. An unlicensed closing agent might miss this. A simple online service would almost certainly overlook it. But Sarah, the lawyer, sees it. Now her job shifts from historian to problem solver. She becomes a skip tracer, tracking down Mrs. Brown, who now lives 3 states away and hasn't spoken to her ex-husband in 20 years. Sarah calls Mrs. Brown. The conversation is tense. Mrs. Brown has no interest in helping her ex-husband sell his house. She feels she was wronged in the divorce. This is the human element of real estate law. It's not just about paper. It's about people, old wounds, and complicated lives. Sarah doesn't just quote the law. She negotiates. She explains the situation calmly, professionally. She explains that clearing this up is a simple matter of signing a document she was legally obligated to sign 2 decades ago. She works with Mr. Gable's lawyer. Maybe a small payment is offered to Mrs. Brown for her trouble, a nuisance fee, to make the problem go away. After several tense phone calls and emails, Sarah succeeds. Mrs. Brown agrees to sign. A new deed is drafted, sent across state lines, signed, notarized, and returned. Sarah files it with the county clerk, and just like that, the cloud vanishes. The title is now clean. The Jacksons' dream home is saved. And they never even had to know the full extent of the drama that was unfolding behind the scenes. They were protected. This entire process culminates in the lawyer's second monumental act of protection: securing title insurance. This is one of the most misunderstood concepts in real estate. It is not homeowner's insurance. Homeowner's insurance protects you from future events: a fire, a break-in, a hailstorm. Title insurance does the opposite. It is a unique form of insurance that protects you from the past. It's a one-time premium you pay at closing that protects you for as long as you own the property, from all those ghosts the title search might have missed. Because no title search is perfect. Humans make mistakes. Clerks misindex documents. Signatures can be forged. A long-lost heir could appear out of the woodwork with a valid claim based on a will that was never properly probated. Title insurance is your financial fortress against these past defects. If someone like Mrs. Brown had refused to sign and later sued the Jacksons for a share of the home, the title insurance company would be legally and financially obligated to defend the Jacksons in court and cover their losses. The lender will always require a lender's policy to protect their investment, the mortgage. But the lawyer's job is to ensure you, the buyer, get an owner's policy. It is the legal armor that guarantees your piece of the American dream is truly yours. The lawyer reviews the title commitment, the formal offer from the insurance company, with a fine-toothed comb. They explain the exceptions, which are any items the policy will not cover, like known easements or restrictive covenants. They ensure the legal description of the property is perfect, down to the last foot and angle, so that what you think you're buying is what you are legally buying. So when your lawyer is conducting a title search and arranging for title insurance, they are not just checking boxes. They are acting as a time-traveling legal guardian. They are sanitizing the property's history, neutralizing ancient threats, and building a legal force field around your future. They are ensuring that the deed you receive at the closing table isn't just a piece of paper, but a clear, unassailable, and legally defensible declaration of ownership. They are making sure your home is a sanctuary, not a potential courtroom. With the finances now locked down and the property's legal history secured, all that's left is to bring every single one of these moving parts together for the final, high-stakes performance. And that performance is called the closing. It's the final scene, the last act where every character, the buyer, the seller, the agents, the lender, and the title company, gathers around a single table. The air is thick with anticipation, a mix of excitement and anxiety. On that table sits a stack of paper so high it looks like a miniature skyscraper. This isn't just paper. It's the legal and financial DNA of your new life. And your lawyer? They're not just in the audience. They're the director, the conductor, making sure every note is hit perfectly, because one wrong move, one missed cue, can bring the entire production crashing down. The star of this show, the main script everyone is working from, is a document called the Closing Disclosure, or the CD. You'll receive this a minimum of 3 business days before the closing. That's not a suggestion, it's federal law. The 3-day rule was designed to prevent you from being ambushed at the closing table with unexpected fees and costs. It's your final detailed look at the numbers, every single penny involved in the transaction. But let's be honest, it's a dense 5-page grid of figures that can make your eyes glaze over. To the untrained eye, it's just a list of debits and credits. To your lawyer, it's a battlefield where thousands of dollars can be won or lost. Their first move is to pull out the initial loan estimate you received from your lender weeks or even months ago, and place it side by side with the closing disclosure. They are hunting for discrepancies. Did the loan origination fee suddenly jump? Are the title insurance premiums what you were quoted? They're checking the prorations, the precise calculations that divide up annual costs like property taxes and HOA fees between you and the seller. If you're closing on June 30th, you shouldn't be paying for the 6 months the seller lived there. Your lawyer is ensuring you're only paying for your exact share down to the day. They're verifying the seller credits you negotiated for repairs. They are making sure every fee, from the appraisal fee to the flood certification fee to the courier fee, is legitimate and accurate. A single misplaced decimal point, a single fee that shouldn't be there, can cost you hundreds, even thousands of dollars. Your lawyer is the human calculator with a law degree, ensuring the final number you need to bring to the table is not a penny more than it should be. Once the numbers are confirmed to be ironclad, the real marathon begins. Signing that mountain of paperwork. This is where the overwhelming feeling truly sets in. You'll be handed document after document, each one filled with dense legalese and told, sign here, initial here, sign here. Doing this without a lawyer is like walking blindfolded through a minefield. Your lawyer transforms this experience from an act of blind faith into one of empowered understanding. They are your translator, your interpreter, your guide through the legal labyrinth. They will pause the rapid-fire signing process and explain exactly what each document means in plain English. Let's pull a few of the most critical ones from the stack. First, the deed. This isn't just a piece of paper. It's the legal instrument that officially transfers ownership of the property from the seller to you. But not all deeds are created equal. Your lawyer ensures you're getting a general warranty deed, the gold standard, where the seller guarantees they have clear title and will defend you against any future claims forever. They scrutinize the legal description of the property on the deed, that block of text that looks like gibberish. They're making sure it's a perfect match to the survey and the title commitment. A single typo in that description, one wrong number in the lot and block, could mean you legally just bought your neighbor's driveway instead of your own house, creating a catastrophic title issue that could take years and a fortune to fix. Next up is the promissory note. This is the simplest and perhaps most terrifying document you will sign. It is your IOU to the bank. It is your direct, personal, and legally binding promise to repay the hundreds of thousands of dollars you're borrowing plus interest. There's no collateral mentioned here. It's just your word, your signature, your promise. Your lawyer confirms that the principal amount, the interest rate, the term of the loan, and the monthly payment schedule on this note are exactly what you agreed to. There is zero room for error here. This is the engine of your financial obligation. And if the promissory note is the engine, the mortgage, or in many states the deed of trust, is the teeth. This is the document that secures the loan. It's what says, if I fail to honor the promise I made in the promissory note, the bank has the right to take my house through foreclosure. It's the security instrument that ties your debt to your property. Your lawyer combs through this document, ensuring it correctly references the property, links back to the promissory note, and doesn't contain any predatory clauses or hidden terms that could put you at a disadvantage down the road. But the lawyer's job isn't just about reading paper. It's about managing last-minute crises. What happens if you do your final walkthrough an hour before closing and discover the seller took the expensive appliances they'd agreed to leave? Or that the hole in the roof they promised to fix is still there, staring at the sky? You're at the table, the money is ready to go, and the deal is about to collapse. Without a lawyer, you panic. With a lawyer, you have a strategist. They will immediately get the other side on the phone and negotiate a solution on the spot. They might arrange for a portion of the seller's proceeds to be held in an escrow account until the repairs are completed, or negotiate a last-minute credit so you can buy a new refrigerator. They are the firefighter who puts out the blaze before it consumes your dream. And then there's the biggest, most terrifying fire of all in modern real estate: wire fraud. This is the moment your life savings are at their most vulnerable. Days before closing, you'll receive instructions on where to wire your down payment and closing costs. Scammers are experts at intercepting these communications. They will create a fake email that looks identical to one from your lawyer or the title company. With one tiny change, the bank account number, they'll create a sense of urgency, telling you to wire the funds immediately to avoid a delay. You thinking you're doing the right thing, send your entire life savings, tens, even hundreds of thousands of dollars, into the digital abyss. And once it's gone, it is virtually impossible to get back. It vanishes in minutes. Your lawyer is your single greatest defense against this catastrophic crime. They will have a rigid, multi-step verification process for all wiring instructions. They will never just email you the instructions. They will call you, using a phone number they gave you at the beginning of your relationship, to verbally confirm every single digit of the account and routing number. They will tell you to be suspicious of any last-minute changes, and to call them immediately if you receive any. This one service, this one piece of diligence, can be the difference between getting the keys to your new home and facing absolute financial ruin. With the money safely transferred and the last document signed, the lawyer's final task is to coordinate the conclusion. They ensure the lender has funded the loan, that all the money is in the right place, and then, most critically, they ensure the new deed and mortgage are immediately sent to the county clerk to be officially recorded. This is the moment it becomes real. The recording of the deed is the public, official act that legally declares you the new owner of the property. Until that stamp hits the paper at the county office, the deal isn't truly done. Your lawyer shepherds this final step, making sure there are no slip-ups. Only then, after the ink is dry, the money is secure, and your ownership is etched into the public record, does the final magical moment arrive. Your lawyer turns to you, smiles, and hands you a set of keys. It's not just a piece of metal. It's a symbol of everything you've worked for, every document you've signed, every dollar you've saved. It's the key to your future, and it was placed safely in your hand because a legal expert was guarding your back every single step of the way. But that feeling of safety, that profound sense of security, isn't just about the moment you get the keys. It's about every moment that comes after. It's about the quiet confidence you have, years down the line, knowing that the foundation of your home isn't just concrete and steel, but a legally sound, unshakable contract. Because the truth is, the dangers in real estate don't always announce themselves with a loud bang. More often they arrive silently, in a plain white envelope, months or even years after you've unpacked the last box. Let's imagine a different story for a moment. A story that happens all too often. Meet David and Emily. They're just like you. They saved, they dreamed, they found the perfect little bungalow with a big backyard for their golden retriever. To save a few $1,000s, they decided against hiring their own lawyer. Their real estate agent was great, the lender seemed to have everything under control, and they used a standard online document service for the paperwork. Everything felt easy, The closing was a breeze. They moved in, painted the living room, and started their new life. 6 months of bliss go by. Then the envelope arrives. It's a certified letter. Inside is a legal notice from a construction company they've never heard of. The letter states that the previous owner of their home had a brand new $25,000 kitchen installed a year ago and never paid the final bill. As a result, the construction company placed something called a mechanic's lien on the property for the full amount, plus interest. David and Emily are confused. This has nothing to do with them. They call the previous owner, but the number is disconnected. They call their real estate agent, who sympathetically tells them, "I'm so sorry, but that's a legal matter. You need to talk to an attorney." The letter is crystal clear. The lien isn't against the previous owner. It's against the property. It's attached to the house itself. And because they now own the house, they own the debt attached to it. The construction company informs them that if the $25,000 isn't paid, they have the legal right to foreclose on the lien, which means forcing the sale of David and Emily's dream home to get their money. In the blink of an eye, their sanctuary has become a hostage. Their equity, their future, is suddenly on the line because of a bill they didn't rack up from a contractor they never met. This is the silent nightmare that a real estate lawyer is trained to prevent. Now let's rewind David and Emily's story and put a lawyer in the picture from day one. What changes? Everything. One of the very first things their lawyer would have done is initiate a comprehensive title search. This isn't just a quick Google search. It's a deep forensic dive into the public records associated with that property. The lawyer's team meticulously scours decades of deeds, mortgages, tax records, court judgments, and divorce decrees. They are hunting for anything that could compromise the chain of title, an unbroken record of ownership. They are looking for clouds on the title, any claim, lien, or encumbrance that could affect ownership. In this version of the story, a paralegal at the law firm, an expert in these searches, would have uncovered that mechanic's lien in a matter of hours. It would have been a glaring red flag on the title report. The lawyer would have immediately called David and Emily and their agent and said, "Stop everything. We have a problem." But it wouldn't be David and Emily's problem to solve. The lawyer would have drafted a formal notice to the seller's attorney, stating in no uncertain terms, "Your client has an outstanding $25,000 lien on this property. The lien must be paid in full, and we must receive a satisfaction of lien document from the contractor before closing. Otherwise, the deal is off, and we will be seeking the return of our client's deposit." Suddenly, the power dynamic shifts completely. The seller, who was hoping to walk away from their debt, is now cornered. They can't sell their house to anyone until that lien is cleared. The pressure is on them, not on the innocent buyers. The seller is forced to pay the contractor. The contractor files the legal document proving the lien has been paid. The lawyer verifies it, and only then, when the title is clean and clear, do they allow the closing to proceed. David and Emily might never even have known the full extent of the crisis that was averted. For them, it was just a minor delay that their lawyer handled. They would get their keys, move into their home, and sleep soundly every single night, with no certified letters waiting in their future. They didn't just buy a house, they bought guaranteed peace of mind. This is the hidden value of a real estate lawyer. They are your private investigator, your shield, and your strategist. And their protection goes even deeper than the title search. What if a lien was improperly filed, or a document was forged 50 years ago? Some issues are so deeply buried that even the most thorough search can't find them. This is where your lawyer becomes your risk manager, guiding you through the critical process of obtaining title insurance. Title insurance is one of the most important and least understood parts of a real estate transaction. It's a unique insurance policy. You pay for it once at closing, but it protects you for as long as you own the property. It doesn't protect you from future problems, like a fire or a flood. It protects you from the past. It insures you against financial loss from defects in the title that existed before you bought the property. That mechanic's lien? An undisclosed heir who claims they actually own 25% of the property? A forged signature on a deed from 1972? All of these are title defects that could lead to you losing your home. A good lawyer doesn't just tell you to get title insurance. They analyze the policy for you. They review the title commitment, which is the insurance company's promise to issue a policy. They scrutinize the list of exceptions, the things the policy won't cover. Sometimes they can negotiate with the title company to have certain exceptions removed, giving you broader protection. They ensure you have an owner's policy that protects your equity, not just the lender's policy that only protects the bank's investment. Without a lawyer, you're just signing a stack of papers, hoping you have the right coverage. With a lawyer, you are making an informed decision, actively securing your investment against ghosts of the past. The transaction you see, the house, the price, the mortgage, is just the tip of the iceberg. Beneath the surface of the water lies a massive, unseen world of legal complexity. Zoning ordinances, boundary line disputes, restrictive covenants from the original subdivision, easements granting your neighbor the right to drive across your lawn. Your real estate agent helps you navigate the visible part of the iceberg. Your lawyer is the sonar operator, mapping out every jagged edge hidden in the deep, ensuring you don't run aground. They are not just facilitating a transaction. They are managing your risk, protecting your future, and turning a house into a home that is truly and unequivocally yours, free and clear of anyone else's claims or mistakes. They are the architects of your security, and that security is not a passive state. It is an actively constructed fortress, built brick by legal brick to withstand the tests of time, disputes, and unforeseen circumstances. Think of it this way: when you buy a car, you check its history, you look under the hood, you take it for a test drive. You're assessing its current state and future reliability. But with a house, you can't test drive the title. You can't look under the hood of its legal history. You are buying a story that stretches back decades, sometimes centuries, a story filled with previous owners, old mortgages, forgotten liens, and boundary line agreements made with a handshake over a fence post. Your lawyer is the one who reads that entire story, chapter by chapter, line by line, looking for the plot twists that could ruin your ending. Let's make this tangible. Imagine two families, the Clarks and the DeVises. They buy nearly identical homes, right next to each other, built by the same developer. The Clarks, wanting to be thorough, hire a sharp real estate lawyer. The DeVises, looking to cut costs, decide to forego a lawyer, relying solely on the standard services provided by their agent and the title company. On the surface, both transactions look identical. Both families get a mortgage, a title search is done, and they both receive a title insurance policy at closing. They move in, plant gardens, and their kids play in the adjoining backyards. For 3 years, everything is perfect. Their stories seem to be tracking on the exact same happy trajectory. Then the letter arrives. It's from the county. It informs them that a 20-year-old paper street, a road that was planned and mapped but never actually built, runs directly through the back third of their properties. The county has now decided to sell this undeveloped right-of-way to a developer who plans to build a new access road for a subdivision going up behind their homes. Suddenly, the Clarks and the DeVises are facing the prospect of losing their beautiful backyards and having a construction zone, and then a busy road just feet from their patios. Panic sets in. Here's where their stories diverge dramatically. The DeVises call their title insurance company. They're frantic, but the company points to a fine print exception in their policy. A standard exception for matters an accurate survey would disclose. The original plot survey did show the paper street, but it was just a faint dotted line, dismissed as an old planning relic by the surveyor and never flagged as a critical issue by the non-lawyer closing agent who was just focused on getting the paperwork signed. The title company says the issue was technically disclosed, even if no one understood its catastrophic potential. The DeVises are on their own. They now face a legal battle against the county and a well-funded developer, a fight that will cost them tens, if not hundreds of thousands of dollars, with no guarantee of success. Their dream home has become a source of unending stress and financial peril. Now, let's rewind to the Clarks closing 3 years earlier. Their lawyer, during her due diligence, didn't just glance at the survey. She saw that dotted line, and her legal training immediately set off alarm bells. A dotted line on a survey map to a lawyer isn't just a line. It's a question mark, a potential claim, a future lawsuit waiting to happen. She didn't dismiss it. She investigated. She pulled the original subdivision plats from the county records. She found the documentation for the paper street. She understood immediately that this wasn't a historical artifact. It was a live legal encumbrance on the property. It was a ticking time bomb. She went back to the seller and laid out the facts. She explained that the property was not being delivered with a clear, marketable title, as promised in the contract. The seller was legally in breach. She gave the seller two options. Either go through the formal legal process of vacating the paper street with the county, a process that would officially extinguish the county's rights and remove it from the maps forever, or the Clarks would walk away from the deal and likely sue for their deposit and expenses. The seller, faced with the collapse of the sale and a future inability to sell the house to anyone else with a competent lawyer, had no choice. They spent the time and money to petition the county. It took an extra 60 days, but the paper street was officially vacated. The Clarks closed on a property that was legally whole. So today, when that letter from the county arrives, the Clarks read it with mild curiosity. Their property is not affected. The new road will have to be routed around their land. Their backyard is safe. Their home's value is secure. Their peace of mind is intact. They never had to fight. They never had to panic. They never had to spend a single cent on litigation. Why? Because their battle was fought and won 3 years earlier, in a quiet office, by a professional they paid to worry for them. The fee they paid their lawyer wasn't a cost. It was the single greatest investment they made in that home. It was the price of certainty. It was the purchase of a future free from a problem they never would have even known existed until it was too late. This is the fundamental truth of a real estate lawyer's role. They are not just a part of the transaction. They are your advocate for the entire life of your investment. They operate in the world of what if. What if there's a forged signature on a deed from 1972? What if the seller is in the middle of a messy divorce and their spouse has a claim? What if the condo association's finances are a house of cards, about to collapse into a massive special assessment? They are trained to see the ghosts in the legal machine, the invisible risks that can materialize years down the road and shatter your financial security. The documents you sign at a real estate closing are some of the most significant legal instruments you will ever execute. They bind you to hundreds of thousands or even millions of dollars in debt. They transfer ownership of what is likely your single largest asset. To sit at that table without your own legal counsel, someone whose only fiduciary duty is to you and you alone, is to walk into the most important financial exam of your life without having studied, hoping you can just copy the answers from the person next to you. But in this exam, everyone else at the table, the seller, the agents, the bank, the title company, is working for themselves. Only your lawyer is working exclusively for you. So when you budget for your new home, don't think of legal fees as an optional extra, like upgrading the countertops. Think of it as the foundation. You would never build a house on a shaky, uncertain plot of land. Why would you build your family's future on a shaky, uncertain legal footing? The value a lawyer provides is not just in the documents they draft or the calls they make. It's in the quiet confidence you feel when you turn the key in the lock for the first time. It's in the knowledge that the home is truly yours, defended against the past and secured for the future. It's the profound peace of mind that comes from knowing an expert navigated the complexities on your behalf, ensuring the place you call home is built not on sand, but on the solid rock of legal certainty. When you sign that final document, you're not just buying a property, you're buying a future. A real estate lawyer ensures that future is built on solid ground.